Hello, my name is Cliff Ely. I'm a workers' compensation attorney in Colorado. I only represent injured workers, and I've been doing it for 27 years. The title of this video is Workers' Compensation 101. I'm going to give you a general overview of how the system works in Colorado. Now, because this is a general overview, I'll not be going into great detail on any one issue. However, you can find more information about these topics in my other videos and also on my website, which is www.elylawfirm.com. You can also call me at 303-785-2828, and I'll answer any questions you have at no charge. The workers' compensation system in Colorado provides benefits to workers who are injured on the job. These benefits include medical benefits, lost wage benefits, money for disfigurement, and money for permanent disability. Dependents of workers who are killed on the job can receive death benefits and funeral benefits. But remember, you can't sue your employer or a coworker for your injuries, like you can, for example, in a car accident. You can sue a third party that causes your injuries, but not your employer or anybody who works for your employer as an employee along with you. That's one of the main purposes of workers' compensation law. It protects employers from being sued for their negligence. After you're injured on the job, you need to report the injury to your employer. The Colorado Workers' Compensation statute says you have 4 days to do this in writing, and if you fail to do so, you can lose 1 day of benefits for each day you're late in reporting the injury. However, this penalty is rarely enforced. Frequently, the employer knows you're injured. They might have witnessed the injury. Sometimes employers will say that because you did not report your injury within 24 hours or 48 hours, you cannot bring a claim. And this is totally false. If that was true, it'd be the shortest statute of limitations in Colorado. Do not be intimidated by statements like this. Frequently, particularly in construction jobs, you don't report every ache and pain that you have. You might wait a day or two to see if the pain goes away. But the best advice is to report the injury as soon as you know that you're really injured. The Colorado Workers' Compensation statute provides that the employer has a choice of what doctor provides treatment to the injured worker. If the employer does not send the injured worker to a doctor, the worker can go to any doctor he chooses. Recently, the law was amended, and it requires that most employers have to give a choice of 2 doctors to the injured worker. Again, if the choice of 2 doctors is not given to the worker, the right of selecting a doctor passes to the employee, and he can choose his own doctor. However, once that choice is made, he cannot switch to another doctor. There are ways to change doctors after a selection has been made. However, it usually requires an agreement between the parties or an order from an administrative law judge. If an injured worker is taken off work for more than 3 days by the treating physician, the insurance company is obligated to pay 2/3 of the worker's average weekly wage, up to a state maximum, and that maximum changes every year. This is called temporary total disability benefits. These benefits continue until the treating physician has said that the claimant can return to work at full duty, or the doctor states that the claimant has reached maximum medical improvement, which means that nothing more can be done to improve the injured worker's condition, or if the employer takes the claimant back to work and offers some work within the claimant's restrictions. If any of those things happen, temporary total disability benefits stop. Now, if the worker is taken back prior to maximum medical improvement and is given a job within his restrictions but is still making less than he was making prior to the time he was injured, the insurance company has to pay the injured worker what's called temporary partial disability benefits. And that is an amount which is 2/3 of the difference between what the claimant was making before he was injured and what he is making when he returns back to work prior to reaching maximum medical improvement. When the claimant reaches maximum medical improvement, the doctor should assign a disability rating to the injury which the claimant received. This disability rating dictates how much permanent partial disability benefits the insurance company owes to the claimant. There are 2 types of disability ratings: extremity and whole person. Extremity ratings are for injuries to the arms or legs or any part thereof. An extremity rating pays the same to any claimant regardless of their age or how much they are making at the time that they are injured. For example, a rating of 10% of the arm is worth around $5,200. and that depends on the date of injury. It changes every year. Whole person ratings are for injuries to the head, neck, back, or the torso. And the value of this rating is based upon the age of the worker and the worker's average weekly wage. The younger you are and the higher wages you are paid, the more you will receive in permanent partial disability if you have a whole person rating. Now, if either party is dissatisfied with the rating that the worker receives, or if the injured worker feels that he is not at maximum medical improvement, either party can request what is called a division independent medical examination. In a division IME, neither side gets to choose the doctor that does the examination. If the parties cannot agree on a doctor, the Division of Workers' Compensation sends a list of 3 doctors, and each side crosses off one of the doctors, and the injured worker goes to the doctor that remains. Do not go through the selection process without the advice of an attorney who knows these doctors. The Division IME doctor will give an opinion regarding the extent of the claimant's disability and whether or not the claimant has reached maximum medical improvement. If the claimant has not reached maximum medical improvement and is still off work with the injury, temporary total disability benefits may still be owed. The opinion of the Division IME doctor is binding upon the parties. The only way to overcome that opinion is to go to court and prove by clear and convincing evidence that the Division IME doctor was wrong. This is usually very difficult to do. Therefore, great care should be taken in selecting the Division IME doctor. The amount of permanent partial disability benefits a worker can receive is limited by statutory caps. There's a maximum you can get, and if the injury happened on or after July 1, 1991, but before January 1, 2006, the most a claimant can receive is $60,000 for ratings of 25% or less, or $120,000 if the rating is above 25%. Also, the amount the claimant has received in temporary disability benefits is counted against these caps. Therefore, if a worker receives temporary total disability benefits for a long time, he may not receive very much in the way of permanent partial disability benefits because of these statutory caps. If your injury occurred on or after July 1, 2006, the caps have changed to $75,000 for ratings of 25% or less and $150,000 for ratings of above 25%. And if you're injured on or after July 1, 2012, these amounts have cost of living adjustments that change every year. If an injured worker is not able to return to work to any job or make any wages, he's probably entitled to permanent total disability benefits. Permanent total disability benefits are paid at the rate of 2/3 of the injured worker's average weekly wage and are paid for the life of the injured worker. If the worker receives Social Security disability benefits, the workers' compensation insurance carrier gets to reduce the permanent total disability benefits by 1/2 of the Social Security disability benefits. If a worker has a scar or a limp as a result of an injury, disfigurement benefits may be paid. The amount of disfigurement benefits varies from year to year depending on the date of the injury. As of July 1, 2011, the maximum you can receive for scarring is $4,396 unless you have extensive scars or a stump, for example, from an amputation. In that case, you can receive a maximum rate of $8,792. If you're not able to settle this issue with the insurance company, an administrative law judge can enter an award for disfigurement benefits. The insurance company has to provide medical care to cure and relieve the effects of the injury. These are called medical benefits. This is usually done with an employer-designated authorized treating physician. When the claimant reaches maximum medical improvement, the doctor should put in his report whether or not ongoing medical care is needed. If the doctor designates that ongoing medical care is needed and no other doctor contradicts this, then the insurance company should provide in its final admission a provision that the injured worker will receive ongoing medical benefits. If an employee is killed on the job, his dependents are entitled to receive 2/3 of his average weekly wage. In the case of children, the amount will be paid until the child reaches 18, or if they go to college, until the child reaches 21. The wife would receive it for the rest of her life unless she remarries. If there are several dependents, the benefit would be divided between those dependents. Also, there is an offset for Social Security disability benefits received by the dependents. As you can see, this is a fairly complicated law. You can go to my other videos for more information about specific areas of workers' compensation, or look at my website at elilawfirm.com. If you have any questions you'd like answered, please call me at 303-785-2828. I'd be happy to provide you with a free consultation.